The marble floors of the Supreme Court echoed with footsteps that morning, the kind of quiet anticipation that settles over a room before something unprecedented unfolds. Nobody walking through those bronze doors expected anything unusual from the oral arguments scheduled for 10 o'clock. The case itself seemed straightforward enough, a voting rights appeal that legal scholars had been tracking for months, but that most Americans barely knew existed. The lawyers had prepared their briefs, the justices had reviewed the materials, and the gallery was filling with the usual assortment of law students, journalists, and citizens who had waited hours for a chance to witness the court in session. Representative Jasmine Crockett sat in the second row, her presence unusual but not entirely unexpected given her background as a civil rights attorney before entering Congress. She wore a navy suit, carried a leather portfolio, and had that same focused energy that anyone who had watched her congressional hearings would recognize immediately. What nobody knew, not even the court security staff who had checked her credentials that morning, was that she was about to engage in an exchange with Justice Brett Kavanaugh that would dominate news cycles for weeks and fundamentally shift how millions of Americans understood the intersection of law, power, and accountability. If you want to see how one moment of preparation and courage can change the entire trajectory of a legal debate, make sure you subscribe to this channel, because what happened next reveals exactly why speaking truth to power still matters in American democracy. The case before the court involved a challenge to new voting regulations in a southern state, regulations that advocacy groups argued would disproportionately affect minority voters by requiring multiple forms of identification, limiting early voting periods, and restricting ballot drop box locations. The state defended the measures as necessary safeguards against fraud, despite presenting minimal evidence that fraud had occurred in previous elections. Jasmine Crockett had filed an amicus brief on behalf of a coalition of civil rights organizations, and while she was not arguing the case directly, she had been invited to observe as a representative of one of the key advocacy groups. Her experience as a defense attorney who had spent years in Texas courtrooms fighting for clients others had dismissed gave her a particular perspective on how legal arguments often masked underlying intentions. She understood the gap between what laws claim to do and what they actually accomplished in practice. As the Chief Justice called the court to order and the attorneys for the petitioners began their opening statements, Jasmine listened with the kind of attention that comes from years of analyzing arguments for weaknesses and inconsistencies. The petitioners' counsel was methodical, walking through the technical aspects of the regulations and arguing that states retained broad authority under the Constitution to manage their own election procedures. The state's lawyer emphasized that the regulations applied equally to all voters regardless of race, a classic equal protection argument that ignored the practical realities of how different communities accessed identification documents and polling locations. 20 minutes into the arguments, Justice Kavanaugh leaned forward and addressed the petitioner's counsel with a question that revealed his apparent inclination. His voice carried that authoritative tone that comes with a lifetime appointment to the nation's highest court, a confidence born from knowing that his words would be analyzed and cited in legal scholarship for generations. He asked whether the court should defer to state legislatures in matters of election administration, suggesting that elected officials understood their communities better than federal judges could from Washington. The question contained an implicit premise: the idea that judicial restraint meant accepting state decisions unless they violated explicit constitutional prohibitions. It was the kind of framing that sounded reasonable on its surface, but that effectively gutted federal oversight of practices that had historically been used to disenfranchise specific populations. The petitioner's counsel agreed enthusiastically, sensing an ally on the bench. As the back and forth continued, several other justices posed questions that seemed to challenge the state's position, but Kavanaugh's interventions consistently steered the discussion back toward deference to state authority. His questions grew more pointed, his tone more insistent. He cited precedents about federalism and state sovereignty, invoking cases that had limited federal intervention in state affairs. Each question built on the previous one, constructing what legal observers would later describe as a roadmap for upholding the regulations. That was when something extraordinary happened, something that court watchers would later say they had never witnessed in their years of attending Supreme Court arguments. Jasmine Crockett quietly stood, not to leave but to signal a request to address the court. The Chief Justice looked startled, Court protocol did not typically allow observers to participate in oral arguments, but before he could speak, one of the attorneys who had submitted the amicus brief made a quick motion to allow Crockett to address a specific point of factual context that had arisen during Kavanaugh's questioning. The motion was unusual but not unprecedented, and after a moment of hurried consultation, the Chief Justice allowed it with the caveat that Crockett would have exactly 3 minutes. The courtroom fell into a different kind of silence now, the kind where everyone suddenly realized they were about to witness something that would be discussed and debated long after the official transcript was filed. Jasmine approached the lectern with steady steps, placed her portfolio down, and looked directly at Justice Kavanaugh. Her voice when she spoke was clear, measured, and carried none of the hesitation that might be expected from someone addressing the Supreme Court for the first time. She began by acknowledging the justice's questions about federalism and state authority, demonstrating that she understood the legal framework he was constructing. Then she did something that made several justices sit up straighter in their seats. She shifted the entire frame of the discussion. "Justice Kavanaugh," she said, "you have asked multiple questions about whether this court should defer to state legislatures in designing election procedures, and you have suggested that elected officials have democratic legitimacy that federal judges lack. That framing assumes that the state legislature in question was itself the product of fair and accessible elections. But the record before this court shows something different. The record shows that the very legislators who passed these voting restrictions were elected under previous restrictions that were themselves challenged and found to have discriminatory effects by multiple federal courts. So we are not talking about deferring to a democratically elected body. We are talking about allowing a legislature that came to power through tainted processes to further entrench those processes. That is not federalism, Justice Kavanaugh. That is a self-reinforcing cycle of disenfranchisement." The courtroom reacted with an audible rustle of movement, journalists leaning forward, law students exchanging glances, even some of the justices visibly responding to the directness of her statement. Kavanaugh's expression shifted from patient attention to something sharper, his brow furrowing as he prepared to respond. Before he could speak, Jasmine continued, and what she said next would become the moment replayed across every news network and social media platform for days afterward. "You asked whether federal courts should second-guess state decisions about election administration," she said, her voice gaining strength. "But the question assumes that all voters have equal access to the legislative process that creates those rules. The data in the record contradicts that assumption. In the 3 counties most affected by these regulations, early voting locations were reduced by 62% in predominantly black neighborhoods, while increasing by 18% in predominantly white neighborhoods. The new identification requirements accept gun permits, but not student identification cards from state universities. These are not neutral administrative decisions, Justice Kavanaugh. These are choices that reflect a clear understanding of which voters are being helped and which are being hindered. And if I may address the court's concern about federal overreach, I would note that the 15th Amendment exists precisely because states proved they could not be trusted to administer elections fairly when left to their own devices. The Reconstruction Amendments were not suggestions. They were commands born from the recognition that some rights are too fundamental to leave vulnerable to local prejudice. Kavanaugh leaned back slightly, then forward again, and his voice when he responded carried an edge that those who had followed his jurisprudence recognized as his confrontational mode. "Miss Crockett," he said, emphasizing the miss rather than representative, "you are asking this court to find discriminatory intent based on disparate impact statistics. But our precedents require more than correlation. They require proof of purposeful discrimination, and I do not see that in the record before us." The exchange that followed would be dissected in law schools and quoted in congressional speeches for months to come, but in the moment it felt less like a legal debate and more like a fundamental clash over who gets to define what counts as evidence and what counts as justice. Jasmine did not hesitate for even a second before responding, and her response demonstrated exactly why she had spent days preparing for this possibility, reviewing case law and historical records and statistical analyses until she could cite them from memory. "Justice Kavanaugh," she said, "the court has indeed established that proving discriminatory intent requires more than statistics alone. But the record here contains far more than statistics. The record includes emails between legislative staffers discussing which demographic groups would be most affected by these changes. The record includes testimony from election officials who stated they were pressured to reduce early voting locations in specific areas despite having adequate facilities and staff. The record includes the legislature's own commissioned study showing that the proposed identification requirements would disproportionately burden minority voters, a study that legislators referenced during floor debates while arguing that these effects were acceptable trade-offs for enhanced security. When legislators are told that a policy will have discriminatory effects, and they proceed with that policy while explicitly acknowledging those effects, at what point does knowledge become intent? She paused, letting the question hang in the air, then continued with even greater precision. Furthermore, the court's decision in Arlington Heights established that impact evidence can be highly probative of intent when combined with historical context and the specific sequence of events, and all three elements are present here. This is not a case where we are asking the court to infer intent from numbers alone. This is a case where the numbers confirm what the documented statements and deliberate choices already demonstrate. Kavanaugh's face had taken on a slight flush, and several court observers would later note that they had rarely seen him visibly unsettled during oral arguments. He responded with a question that seemed designed to reframe the debate on more favorable ground, asking whether Crockett was suggesting that any voting regulation that had disparate effects should be struck down, which would, he said, effectively prevent states from implementing any security measures whatsoever. It was a classic slippery slope argument, one that attorneys and judges often deploy to suggest that a ruling would lead to absurd outcomes. But Jasmine had anticipated exactly this response, and what she said next was delivered with such clarity and force that even the justice's ideological allies on the bench appeared to be listening with full attention. "No, Justice," she replied. "I am not arguing that disparate impact alone invalidates a law. I am arguing that when disparate impact is combined with evidence of discriminatory purpose, historical context of discriminatory practices, and the absence of any legitimate justification that could not be achieved through less restrictive means, then the Constitution requires this court to act. The state has presented no evidence of significant fraud that these measures would prevent. None. They have produced no studies, no investigations, no prosecutions that would justify the burden these regulations impose. What they have produced is a policy that makes voting harder for specific communities while offering no corresponding benefit to election security. That is not a close call, Justice Kavanaugh. That is exactly what the Voting Rights Act was designed to prevent." The tension in the courtroom had reached a level that made even routine procedural moments feel charged with significance. Several justices began asking questions of their own, some appearing to probe weaknesses in Crockett's argument, while others seemed genuinely engaged with her framework. But Kavanaugh was not finished, and his next question revealed both his legal philosophy and perhaps something more personal. He asked whether Crockett believed that every policy disagreement over election procedures should become a federal case, whether states had any autonomy left under her interpretation of the Constitution. His tone had shifted from judicial inquiry to something closer to cross-examination, the kind of aggressive questioning that trial lawyers use to rattle witnesses and expose inconsistencies. But if he expected Jasmine to become defensive or flustered, he had fundamentally misread the person standing before him. She had spent years in courtrooms where judges and opposing counsel had tried to intimidate her, where being a black woman attorney meant constantly having to prove her competence and right to be heard. This was not her first confrontation with power that questioned her legitimacy, and it would not be the last. Her response was not defensive but expansive, taking the question and using it to articulate a vision of constitutional interpretation that directly challenged the originalist framework that Kavanaugh and several other justices championed. "Justice Kavanaugh," she said, "you ask whether every policy disagreement should become a federal case, but that framing misunderstands what is at stake here. We are not talking about policy disagreements. We are talking about fundamental rights. The right to vote is not a policy preference subject to democratic deliberation. It is the precondition for democratic deliberation. When legislators manipulate election rules to entrench their own power, they are not exercising democratic authority. They are subverting it. And yes, the Constitution does limit state autonomy in this area because the framers and the subsequent amendment process recognize that some rights are too important to leave entirely to local control. That is not judicial activism. That is faithful application of constitutional text and structure. She paused again, and when she resumed speaking, her voice carried a different quality, something that those present would later describe as both passionate and controlled. The voice of someone who understood that this moment mattered beyond the immediate legal question. "You mentioned autonomy," she continued, "and I want to address that directly, because I think it reveals a fundamental disagreement about what federalism means. Federalism is not a license for states to violate constitutional rights. It is a framework for allocating governmental powers in ways that protect liberty. When states use their autonomy to restrict the franchise, they are not exercising federalism, they are perverting it. The whole point of the Reconstruction Amendments was to establish that states cannot hide behind sovereignty claims when they trample fundamental rights. That principle is not up for debate every time a new restriction is challenged. It is settled constitutional law." Kavanaugh leaned back in his chair, and for a moment he appeared to be considering how to respond. But before he could formulate his next question, Justice Sotomayor interjected with a query that built directly on Crockett's framework, asking the state's attorney to address the specific evidence of legislative statements that Crockett had referenced. The momentum had shifted, and several other justices began asking questions that suggested serious skepticism about the state's position. The dynamic in the courtroom had fundamentally changed, not because Jasmine had delivered a dramatic gotcha moment, but because she had systematically dismantled the intellectual framework that Kavanaugh had been constructing throughout the arguments. She had shown that deference to state authority was not a neutral principle, but a choice with consequences, and that those consequences fell disproportionately on communities that had historically been excluded from full political participation. The remainder of the oral arguments continued for another 40 minutes, but legal observers would later note that everything after Crockett's intervention felt different, as though the justices were now grappling with questions they had not fully considered before she spoke. When the court finally adjourned, the reaction was immediate and intense. Journalists rushed from the courtroom to file stories, their editors demanding immediate analysis of what had just transpired. Social media exploded with clips of the exchange, some posted by people who had been in the gallery and recorded audio on their phones, despite the nominal prohibition. Others transcribed from the official audio feed that the court released. Within 2 hours, hashtags about the confrontation were trending nationally, and legal commentators from across the political spectrum were weighing in on both the substance of Crockett's arguments and the propriety of her having been allowed to address the court in the first place. The conservative legal establishment reacted with outrage, some calling the exchange a breach of protocol and demanding investigations into how Crockett had been permitted to speak. Several prominent law professors aligned with the Federalist Society published statements arguing that allowing a member of Congress to participate in oral arguments created dangerous precedents and threatened judicial independence. They framed Crockett's intervention as political grandstanding, an attempt to pressure the court through public spectacle rather than legal reasoning. But others, including some conservative legal scholars who had grown uncomfortable with the court's increasingly aggressive rollback of voting rights protections, acknowledged that Crockett had raised serious questions that deserved answers. A former federal judge appointed by a Republican president wrote an op-ed noting that while the procedure was unusual, Crockett had done exactly what advocates are supposed to do. She had forced the court to confront facts that complicated its preferred narrative. Meanwhile, progressive activists and civil rights organizations celebrated the exchange as a rare moment of accountability, when someone with standing and expertise directly challenged a justice's reasoning in real time, rather than through the slow process of briefs and academic articles. Videos of the confrontation were viewed millions of times, with many viewers expressing shock that such direct challenges to Supreme Court justices were even possible. For Americans who rarely paid attention to oral arguments or the intricacies of constitutional law, the exchange provided a window into how legal reasoning often reflected underlying values and assumptions rather than neutral application of precedent. The broader implications of the confrontation extended beyond the immediate case before the court. Jasmine Crockett became a focal point for discussions about the role of Congress in checking judicial power, particularly at a moment when the Supreme Court had assumed an increasingly central and controversial role in American governance. Several other members of Congress began discussing whether they should take more active roles in Supreme Court cases that touched on their legislative responsibilities. filing amicus briefs, and even seeking opportunities to participate in arguments when relevant. The debate over court procedures intensified, with some arguing that the Supreme Court had become too insulated from democratic accountability and that allowing more diverse voices in oral arguments could improve the quality of judicial reasoning. Others maintained that the court's independence required strict limits on who could participate in proceedings, warning that allowing political figures to engage directly with justices would transform legal arguments into political theater. But what could not be denied, even by Crockett's critics, was that her intervention had been substantive rather than merely rhetorical. She had not relied on emotional appeals or partisan talking points. She had engaged with case law and constitutional interpretation at the highest level, demonstrating command of legal doctrine that rivaled or exceeded many of the attorneys who regularly argued before the court. Several law professors assigned the exchange as required reading in their constitutional law courses, using it to illustrate debates over interpretive methodology and the relationship between courts and democratic institutions. Behind the scenes, sources close to the court reported that the justices themselves had intense discussions about the exchange during their private conferences. According to these accounts, which were never officially confirmed but were reported by multiple journalists with reliable court sources, Justice Kavanaugh felt that he had been ambushed and that the Chief Justice should never have allowed Crockett to speak. Other justices reportedly pushed back, noting that Kavanaugh had opened himself to the challenge by asking such pointed questions that invited factual responses, and that Crockett had been recognized under established procedures for amicus participation. The substance of her arguments had also apparently generated debate among the justices, with some acknowledging that she had identified genuine weaknesses in the state's case that required more careful consideration. The decision in the case would not be released for several months, as Supreme Court opinions typically take considerable time to draft, circulate, and revise. But legal observers noted that the oral arguments had been unusually contentious and that the vote might be closer than initially expected. Some predicted that the court would issue a narrow ruling that decided the immediate case without establishing broad precedents, a strategy that justices sometimes employed when they were deeply divided over fundamental principles. Others suggested that the confrontation might actually embolden the conservative majority to issue a sweeping decision that firmly established their vision of limited federal oversight of state election procedures, using the opinion to respond to criticisms that Crockett had articulated. In the weeks following the oral arguments, Jasmine Crockett found herself in an unexpected position as a national figure in debates over judicial power and voting rights. She received invitations to speak at law schools, civil rights conferences, and congressional hearings about Supreme Court reform. Some of these invitations she accepted, using the platform to articulate a broader critique of how the court had systematically dismantled voting rights protections over the past decade. Other invitations she declined, recognizing that her effectiveness depended on maintaining credibility as someone who engaged with legal substance rather than political celebrity. In interviews, she was careful to emphasize that her intervention at the court had not been about personal confrontation with Justice Kavanaugh, but about ensuring that the factual record was accurately represented. She noted that appellate judges, including Supreme Court justices, often worked from abstractions and legal theories that could obscure practical realities, and that advocates had a responsibility to ground legal arguments in the lived experiences of affected communities. When asked whether she thought her intervention had changed any minds on the court, she was characteristically direct, saying that she had no illusions about converting justices who had spent careers developing contrary jurisprudence, but that forcing them to address inconvenient facts might limit the scope of a bad decision or provide ammunition for future challenges. The case also highlighted broader tensions about the Supreme Court's role in American democracy, at a moment of deep polarization and institutional strain. Public confidence in the court had declined significantly in recent years, particularly after controversial decisions on abortion rights, environmental regulation, and executive power. Many Americans across the political spectrum had come to see the court less as a neutral arbiter of constitutional meaning, and more as another partisan institution pursuing ideological agendas. The exchange between Crockett and Kavanaugh seemed to crystallize these concerns, providing a concrete example of how justices' personal convictions and political commitments shaped their legal reasoning. For some viewers, Crockett's intervention demonstrated that justices could and should be challenged when their arguments rested on flawed premises or ignored relevant evidence. For others, the confrontation reinforced fears that the court was becoming just another arena for political combat, with advocates seeking viral moments rather than careful legal analysis. These competing interpretations reflected deeper disagreements about what courts should do and how they should relate to democratic politics, questions that American society has grappled with since the founding, but that felt particularly urgent in an era of narrow majorities and consequential decisions. Several months later, when the court finally released its decision, the ruling was narrower than either side had hoped or feared. The court upheld some aspects of the challenged regulations while striking down others, issuing a fractured set of opinions that left considerable uncertainty about what standards would apply in future cases. Justice Kavanaugh wrote a concurring opinion that did not directly address the exchange with Crockett, but that emphasized the importance of judicial restraint and deference to democratic processes. Reading between the lines, legal scholars detected traces of the oral argument confrontation, particularly in passages where Kavanaugh insisted that courts should not substitute their judgment for elected officials, except in cases of clear constitutional violation. But the opinion also included language acknowledging that states bore some burden to justify regulations with discriminatory effects, a concession that some attributed to the effectiveness of Crockett's arguments in highlighting the weakness of the state's evidentiary showing. The decision satisfied no one completely, with voting rights advocates disappointed that the court had not gone further in protecting access to the ballot, and conservative activists frustrated that the court had not fully endorsed state authority over election procedures. But several legal commentators noted that the decision could have been much worse for voting rights, and that Crockett's intervention may have contributed to a more cautious approach that preserved some federal oversight capacity. The lasting significance of the confrontation extended beyond the immediate legal outcome. Jasmine Crockett had demonstrated that speaking directly and forcefully to power, even power as formidable as a Supreme Court justice, remained possible and potentially effective. Her willingness to challenge judicial reasoning in real time, using facts and legal arguments rather than deference or rhetorical flourishes, provided a model for how advocates could engage with courts even in an era of conservative judicial dominance. She had shown that justices were not infallible oracles of constitutional meaning, but human beings whose reasoning could be questioned, tested, and sometimes shifted through rigorous engagement. The exchange also revealed something important about the relationship between legal expertise and democratic participation. Crockett brought to the courtroom not just legal training, but lived experience and community knowledge that informed her understanding of how voting regulations actually functioned in practice. Her arguments were powerful, precisely because they combined doctrinal sophistication with grounded awareness of real-world impacts, refusing to let legal abstractions obscure concrete harms. This integration of technical expertise and democratic accountability represented a challenge to legal elites who often treated constitutional interpretation as a specialized domain insulated from broader public input. In the years that followed, the moment would be remembered and invoked in different contexts as an example of courage, preparation, and the ongoing struggle to make America's legal institutions accountable to its democratic ideals. Law students would watch the footage and debate what it revealed about judicial philosophy and advocacy strategy. Civil rights organizations would cite it as evidence that direct confrontation with judicial power remained both necessary and possible. Political figures across the spectrum would reference it when discussing court reform proposals, though they would interpret its lessons very differently depending on their ideological commitments. And ordinary citizens, particularly those in communities affected by voting restrictions, would remember it as a rare moment when someone with authority and expertise spoke clearly about injustices that too often remained hidden behind legal jargon and procedural complexity. The confrontation had not resolved the underlying tensions over voting rights or judicial power, but it had illuminated them with unusual clarity, forcing Americans to grapple with questions about who gets to vote, who gets to decide, and whose voices count in shaping the nation's constitutional commitments. If that exchange made you think about how legal arguments shape real lives and real rights, hit that subscribe button and turn on notifications because these battles over democracy and justice are far from over, and we will continue following every development that determines whether America lives up to its promise of equal political participation for all its citizens.